5 seconds to go. Start. To test whether interference is warranted, this court has laid down that the scrutiny ought to be confined to finding out whether the disciplinary proceedings have been conducted fairly. If not, an inference can be drawn that this has caused prejudice to the charged employee. Be that as it may, there can be no gainsaying that the consequences of violation of a fair procedure, which principles of natural justice embody in a given situation, has to be considered on a case by case basis, bearing in mind that judicial review is not intended to be an appeal in disguise. Though the rules closely associated with the traditional concept of natural justice may not have been breached in this case, the contention of the appellant that the process of decision making stands vitiated for lack of procedural fairness has to be examined given the nature of challenge raised. Memory refreshed, we now proceed to examine whether the appellant had set up any case for interference. The second and the fourth charges levelled against the appellant that he had proceeded on leave without sanction thereof and in not complying with the orders of his superior officers seem to be the most vital charges. Undoubtedly, no public servant can claim leave as a matter of right. Leave is a matter regulated by rules, and such rules need to be duly adhered to by each public servant. While there can be no quarrel on this aspect, we have not found any such circumstance from the record to afford ground for holding that the appellant did commit a serious misconduct. In order to establish that the appellant had committed a serious misconduct by proceeding on leave without leave being sanctioned, leave cancelled as per PW1, the prosecution endeavoured to prove that the civil surgeon had refused to sanction leave prayed by the appellant and that he was telephonically informed by the senior assistant of such refusal, that the appellant had visited the office of the civil surgeon, remained there from 3 p.m. to 5 p.m. and submitted his application for leave, which was duly acknowledged, have not been disputed by the prosecution. Interestingly, the inquiry officer, while exonerating the appellant of the second part of the third charge, reasoned that neither the senior assistant had been produced in the inquiry as a witness, nor were call details produced, and what PW1 said is mere hearsay. Hence, in the absence of proof, that part of the charge is not proved. This was a valid reason assigned by the inquiry officer, which the disciplinary authority even accepted. On the same analogy and for the same reason, the appellant could not have been held guilty in respect of the second charge. There is no record of the civil surgeon's refusal to sanction leave being communicated to the appellant either. In such view of the matter, we have no hesitation to hold that there was no legal evidence based whereon the appellant could have been held guilty of the second and fourth charges, that the appellant did not comply with the directions of the Election Commission and did not participate in the Pulse Polio program constitute the first charge and the first part of the third charge respectively. The second part of the third charge of the appellant having threatened the senior assistant has not been found to be proved. It is the clear finding of the inquiry officer based on the evidence on record that the appellant was not assigned any duty in connection with election duty and pulse polio program during the period He wished to avail leave to attend court proceedings before the High Court. Insofar as defiance of Elections Commission's directions by the appellant are concerned, no such written directions were part of the documentary evidence led before the inquiry officer. Though the letter of the MD-PHC was not made part of the evidence, we shall assume that the appellant PW1 and the inquiry officer knew the contents of the said letter and were aware that in view of the ensuing elections in February 2017, instructions had been received not to grant leave to any officer unless permitted by the Director Health. However, the appellant's contention that public servants on the verge of retirement are not assigned election duty was not shown to be incorrect and untenable. Rather curiously, the inquiry officer resorted to ingenuity to hold the appellant guilty. As is evident from the report, the prosecution having failed to establish that the appellant had been assigned election duty as well as duty associated with the pulse polio program, the inquiry officer went on record to hold the charges under consideration proved by referring to what was, in his perception, the duty of a senior medical officer who has been in charge of an organization. It needs no discussion that the inquiry officer found the appellant guilty for a perceived failure to perform a moral duty. Not only was it completely extraneous, but such a finding was clearly at variance with the charge levelled against the appellant. We hold that holding the appellant guilty of a perceived failure to perform a duty not being the charge in respect of which any opportunity of explanation was given, such a finding could not have been taken into consideration by the disciplinary authority to impose penalty on the appellant. The order of penalty passed by the disciplinary authority dated 11th October 2019 on another count does not also commend to be legal and valid. A detailed response to the inquiry report had been submitted by the appellant, dismissing the claims by a single sentence that the same are not acceptable is not part of a fair procedure. This is a substantial ground for which appellant's grievance seems to be justified. We have extracted verbatim supra the reasons assigned by the division bench in support of the ultimate order it passed modifying the penalty. It is not in doubt that in a rare and appropriate case to shorten litigation and for exceptional reasons to be recorded in writing, a high court may substitute the punishment imposed on the delinquent employee. However, what has overwhelmed our ability of comprehension is that the division bench, despite having returned clear findings in favor of the appellant, adopted a hands-off approach by leaving the findings with regard to the charges untouched. Stop.